Welcome to a special edition of Legal AF. In the last 3 or 4 days, we had some good news coming out of the United States Supreme Court for a moment, and that has to do with same-sex marriage. We've been tracking very closely a case brought by Kim Davis, the disgraced clerk of Rowan County, Kentucky, who many years ago decided that her religious faith would allow her to deny people a marriage license, even though that was her job in government. She didn't work in a church, she worked in a government. She didn't want to issue those marriage licenses because she didn't agree with same-sex marriage. And she got sued under a civil rights statute, and she lost. And she got hit with $330,000 or more in fines. And I thought that was the last we'd hear of Kim Davis, and the electors, the electorate in her home state thought that too, and they didn't reelect her to that position. But Kim Davis is back as the stalking horse for the right wing and the conservative religious movement, who decided to use her case to try to get the Supreme Court, on an invitation by Clarence Thomas, to take a look at same-sex marriage again. A constitutional right that's been in place for at least 10 years, that has over, let me just get the numbers right, 1.6 million Americans are in a same-sex marriage. 300,000 children are part of that marriage. 70% of America believes it's the right thing to do to let people marry those who they want to marry, and yet Kim Davis was back. So we were all on pins and needles about whether the Supreme Court was going to take up her appeal or not, off of what Clarence Thomas had said back 2 years ago in the Dobbs decision, basically inviting this type of appeal. And I couldn't think of anybody better to bring on to brief our audience than Robbie Kaplan. People know Robbie for many, many reasons. She's the lawyer extraordinaire for E Jean Carroll. We'll talk a little bit about the developments in her case at the end. But she also has a vested interest in same-sex marriage and argued at the United States Supreme Court for one of the major cases upon which the same-sex marriage decision was based, the Obergefell case, a case related to the Defense of Marriage Act. So I wanted to bring Robbie back on the show for a briefing. Hi, Robbie.
Hey, how you doing?
I'm doing fantastic. So let me turn it over to you. I think I've set the stage there. How did you read the far right trying to use Kim Davis as the model citizen to bring a case back to the Supreme Court, thinking they may have had the numbers to rip away the second constitutional right in the last 50 years, first one being reproductive rights of women, and take away same-sex marriage of all things? Give us your view on that.
So first of all, let me say the reliance on Kim Davis, while odd, given the history you just gave everyone, is not surprising in the sense that the far-right groups out there are desperate to get rid of marriage equality. And they're going to have a hard time finding the right, I'm going to use Supreme Court language now, the right vehicle to do so, right? Who's going to have standing right now to say that I have such a personal interest and such a personal injury in the fact that my next door neighbors are married, who happen to be gay are married, that the court is going to accept that as a legitimate plaintiff? And it's, they're a bit between a rock and a hard place here, because the law of standing is very hard and very tricky. You have to show a concrete injury. And it seems to me it's going to be hard for them to find the right kind of plaintiffs to do that, unless it's in the religious context, which I can touch on. But in a regular kind of non-religious context, I think they're going to have a very hard time, and they know that. So that's why they were using Kim Davis. Now, one of the many interesting things about Kim Davis is how long it has taken. The Obergefell decision came out in June 2015. I think this case arose shortly after that, where she refused to provide a marriage. And it's been 10 years, and it's still going on today.
I thought she was back under the rock she crawled out from under.
She's back, but she's coming back out. I don't think we've seen the last of her. In terms of the case itself, it seems to be a particularly weak, again, I'm going to use this fancy SCOTUS term, vehicle for the Supreme Court to take up this issue for a bunch of reasons. One, the argument that Obergefell should be overruled was not made in the case below. And generally speaking, you cannot raise arguments at the Supreme Court that have not been raised in the district court and then the appellate court first. Two, Kim Davis is a government official. As you said in your introduction, her job actually was to give people marriage licenses. So a lot of the religious freedom issues that concern, I think, a significant number of the members of the court are of no application here. You don't have a religious right not to deliver mail. You don't have a religious right not to arrest a shoplifter. And you don't have a religious right as a government employee not to issue a marriage license to someone who's entitled. So it was a bad case for those reasons, too. On top of that, we all know they're pretty busy, the Supreme Court today. Not only do they have their regular docket, but they have this kind of shadow docket of stays and then injunctions and then stays, which is taking up a lot of their time. And my guess is, even for the justices who really want to revisit this, there was probably some acknowledgement that this is not really the right time to do so. We're very busy.
Yeah.
And in terms of the ultimate issue, if they do take it up in the future, I'm still confident. I don't think they have 5 votes on that court to subvert the reasonable and settled expectations of, as you just put it, over 1 million people and 300,000 kids. It's very hard to say to a kid, sorry, you thought your parents were married, just kidding. I think that's a very, very, very huge step for them to take. And while there are probably at least two justices who are willing to take it, I don't think the majority is.
So I agree with you. Let me just read to you what the Liberty Council's founder, Max Staver, said about the case. He said that poor Kim Davis, he said the financial burden on her for having to pay the $330,000 fine and damages is crippling based on nothing more than purported hurt feelings. This is how they saw the case. He maintained, however, that the Obergefell case was egregiously wrong from the start, which is what they used to say about Roe. It's not a matter of if, but when the Supreme Court will overturn Obergefell for same-sex marriage. But you don't see that.
I don't see that. I would expect him to say that. I think he's doing a lot of rah-rah for his own position, but I don't think that will happen. And if you think about it, just try to change the situation. Imagine Kim Davis, that a black man and a white woman had come in to get married. And she had said to them, I don't believe in biracial. My religion does not permit biracial marriage. I'm not giving you a license. People would think $300,000 is too little of a fine to impose upon her for doing that.
Like if Clarence Thomas and Ginny Thomas went to go get their marriage license.
Exactly right. So I don't think first of all, she could have actually given them the license early, and then she would owe $300,000. And 2, she could have been reasonable at any point in the last 10 years.
Right.
And she wouldn't have to pay this fine. It's hard to feel very sorry for her.
Let me reinforce your observation with a couple of clips. I've got one of Amy Coney Barrett while she was she's trying to sell her book over the summer, made a comment in response to, I think, Nora O'Donnell. And then I've got a clip from Alito from a few years ago. And I want to see how you interpret that. As you said, as the Supreme Court tries to count to 4 to take the appeal and 5 to overturn Obergefell. Let's play the Amy Coney Barrett interview first.
Court has held that the rights to marry, engage in sexual intimacy, use birth control, and raise children are fundamental. But the rights to do business, commit suicide, and obtain abortion are not.
Right. I'm describing the doctrine. I was a con law professor for many years. Yes, I described the doctrine in the book, and that is the state of the law, which I described in the book because I want people to understand it. I want Americans to understand the law, and that it's not just an opinion poll about whether the Supreme Court thinks something is good or whether the Supreme Court thinks something is bad. Mm-hmm. You know, what the court is trying to do is see what the American people have decided. And sometimes the American people have expressed themselves in the Constitution itself, which is our fundamental law, sometimes in statutes. But the court should not be imposing its own values on the American people. Mm-hmm. That's for the democratic process.
And so when Hillary Clinton, for example, says, what's next? She said, my prediction is the court will do to gay marriage what they did to abortion.
Well, I think people who criticize the court or who are outside say a lot of different things. But again, the point that I make in the book is that we have to tune those things out. So,
but you also say in the book that the rights to marry and engage in sexual intimacy and use birth control and raise children are fundamental.
Yes, again, I'm describing what our doctrine is, and that is what we've said. Mm-hmm.
So let's put Amy Coney Barrett as a no. Let's put her down for a no on taking away gay marriage. You agree?
I think that's right. I think she's quite a religious person, but I think she believes in respecting other people's dignity. I don't think she would be willing to do to all those couples and families what overruling Obergefell would do. I
Right.
don't think she's got it in her heart.
And Alito has said things out loud that would suggest that he doesn't think he's going to be doing that either, regardless of if they get past the vehicle, the plaintiff, the standing issue, and suss this out from First Amendment, from religious freedom issues. I don't think he's there either. But let me play a clip for you and the audience of Alito a few years ago.
Carlin's list seems like a quaint relic, but it would be easy to put together a new list called Things You Can't Say If You're a Student or Professor at a College or University or an Employee of Many Big Corporations. And there wouldn't be just 7 items on that list. 70 times 7 would be closer to the mark. I won't go down the list, but I'll mention one that I've discussed in a published opinion. You can't say that marriage is a union between one man and one woman. Until very recently, that's what the vast majority of Americans thought. Now it's considered bigotry. That this would happen after our decision in Obergefell should not have come as a surprise. Yes, the opinion of the court included words meant to calm the fears of those who cling to traditional views on marriage. But I could see, and so did the other justices in dissent, where the decision would lead. I wrote the following. I assume that those who cling to old beliefs will be able to whisper their thoughts in the recesses of their homes. But if they repeat those views in public, they will risk being labeled as bigots and treated as such by governments, employers, and schools. That is just what is coming to pass.
Now, I have to tell you, Robbie, when I saw that, I hadn't seen that in a while, I thought it was AI. Because I had forgotten how he presented that at the speech he was given. I was like, is this an AI version of Alito?
Sure? We're sure it wasn't AI?
I double checked. No, he gave that speech that way.
Something?
Yeah. So it's not exactly where we want to be in the point, but do you see Alito joining? When you said there's 2, we know it's Thomas because he invited it with substantive due process in his concurrence in Dobbs. Do you think Alito's there too?
I think it depends on the case. I mean, it's very interesting to hear Justice Alito say what he says there because no one is prevented from saying they disagree with same-sex marriage. The freedom of speech is the right to say things, which people have the right to say, and the right of people to disagree with what they say. That's the essence of our First Amendment right. And while people may not like it, people may not want to be friends with someone who says it, that's not a First Amendment right. And so I'm a little curious about what he was saying there. I get the fact that there are really strong disagreements in our society between people who support marriage equality and people that don't. But there's no law that says you can't say you don't support it. There are many, many people who do, including Matt Staver, who you quoted a couple minutes ago.
Yeah. Yeah. And that's in contrast to something you alluded to earlier, which is the Supreme Court said that a baker doesn't have to bake a cake for same-sex married couples because it's compelled First Amendment speech, doesn't have to make a website, even though apparently she didn't even have a website business, but doesn't have to build a website because that's compelled First Amendment speech, right? Is that the dividing line here on the court?
I think up to now, I think their best shot of going after marriage equality and same-sex marriage is for them to kind of shave away the right by this idea that people have their own religious beliefs. And if there's private businesses, unlike Kim Davis, they have a right to not be compelled to do things for gay marriage couples if that's against their religion. That is the law today, and I understand that's the law. I don't think that leads to overturning Obergefell. And I think in a certain way, what Justice Alito is saying there supports my position because people have the right to have a healthy debate. The court has reached a ruling. There are lots of gay people who are married. And the question now is, do you want to take that away? And I understand that the same issues existed with Roe. I'm not saying they didn't. It's just a little different, I think, to tell women that they no longer, in many states, will not have the right to have an abortion, as opposed to telling a family of 2 kids and 2 parents, you're not a family the way you thought you were 5 days ago.
And you hear it even with the right wing, because they talk about the reliance interest having been so great and overwhelming, people relying on this to shape their lives, that they don't want to be the ones to pull the rug out for them, but they don't use the R word, reliance interest, when it comes to reproductive rights or a right of a woman to choose, right?
Yeah. Correct. And I'm not saying I agree with that, but I
Right.
think it's going to be a step too far here when it comes to marriage equality.
Well, you were I keep reminding you, but you were on a Legal AF episode the day the Dobbs decision leaked in March. And we were going to talk about E Jean Carroll. We ended up talking the entire episode about the Dobbs leak.
Wow.
And you said, and my paraphrase, but it's stuck with me ever since, seared in my brain, and it's true. It is the first time in U.S. history that a constitutional right once given was ripped away by a subsequent court.
That's absolutely correct. Let's just hope it's the last time.
Let's hope it's the last time. So let me switch gears for a minute and update our audience about E Jean Carroll, because we get a lot of questions asked. She's been interviewed on Legal AF on Court of History. I joined that back in July, and people are big supporters of what you're doing for her and for E Jean Carroll, particularly in her case. There's 2 judgments that she received. The first one was the first case that went to trial, where she obtained from a jury 9-0 in New York, federal jury, a $5.5 million. If I get the numbers wrong, you'll correct me.
I think it's 5 even.
5 even, which was a finding of a judgment that Donald Trump sexually abused her under New York law as he attacked her in that dressing room in Bergdorf Goodman, and punitive damages. A second trial a few months later, presided over by the same Judge Kaplan, in which a second jury, 9-0, came back at $83.5 million. Having been instructed properly that it was already law of res judicata or collateral estoppel, whatever it was at the moment, that the sexual abuse had already occurred. They were there to figure out punitive and other types of damages. He's appealed in different ways, Trump has, both of these judgments having come out. The one at the $5 million level made its way all the way through where you've been winning up to the Second Circuit Court of Appeals. But now Trump, in the last week or so, has taken an appeal, last-ditch effort at the United States Supreme Court, while the $83 million one is still down at the Second Circuit while he seeks a full court en banc review. Is that about right?
That's exactly right. I think the one kind of guidepost here is that every possible way that a litigant can take to try to slow down a case or not pay a judgment, Donald Trump has taken here.
Yeah,
we're just at different stages in both cases, but that's what we're going to see throughout.
Well, tell our jury the trials concluded when and what year?
2022.
2022, right? Yeah. Last I looked, we're approaching 2026. And she's been hanging in there and waiting valiantly, and every step of the way, you by her side with your legal team, and winning at every level. You have briefs due in both matters, right?
We do. We have on the Second Circuit, which is the second verdict, we have 2 separate briefs due explaining to the court why they shouldn't take it what's called en banc. The entire court shouldn't take the case again. And at the Supreme Court, we just got this week what's called a cert petition from Trump's lawyers, and we're going to be doing a brief in opposition to that, explaining why we don't think the Supreme Court should take the case. And
at the Second Circuit, they need a majority of all the judges of the Second Circuit to agree for an en banc review, right? Correct. All active judges. What I don't know to this day is how many it took to ask us to brief it. And it's not in their rules. We've been losing our minds to figure it out. It's somewhere between 1 and 3, we think, but we're not exactly sure. I just kind of figure that all out for the Ninth Circuit for some of these National Guard cases where 29 judges vote, but then they got to be 14, and then there's a panel of 11. I mean, it's very, very complicated, this whole thing. Right. And the reality is, if they do en banc, which I'll say it, I don't think is likely. Good luck to you. That then they vacate the 3-judge panel ruling in your favor, and they decide to do it all over again. I just don't see that happening. And just my view, but I'm sure your briefs will be very, very good. On the Supreme Court level, they'll have to decide to take up this appeal. They'll need 4 votes to do it and 5 to vote in favor of Donald Trump. And we'll look for it. Will it be like on an order list like we got for Kim Davis's case? It will be, but it could take them some time. I mean, typically the case they'll think about it over and over again. Yeah. On the Second Circuit, I can only add that the Second Circuit is famous for not doing en bancs. The belief it's a tradition there, and the belief, which is probably correct, is that taking en bancs is dangerous or impairs the collegiality of the court. That's right. So if the Second Circuit takes it once a year, once every other year, that's a lot. Yeah, that's why people who follow my work closely, God, Popok never talks about a Second Circuit en banc because they don't happen, because it does undermine. You got every justice is done 99.9% of the time by a random 3-judge panel of a circuit court. That is your Ninth Circuit. That is your Second Circuit. That is your whatever. I've argued at these courts, and you may not like your 3-judge panel, but that is your circuit court for the purposes of that ruling. And then, of course, you almost never get the en banc. It happens rarely, although people may not know that, because in some of these Trump cases, he is getting or he's at least asking for en banc. Like, for instance, just to round it out, Judge Immergut's decision about the National Guard, there was an adverse ruling against her by a 3-judge panel, but the Ninth Circuit took a look and didn't like what happened there with the 3-judge panel that didn't support Judge Immergut, and they did vacate that decision, and they are pulling it back up for an en banc review.
And the Ninth Circuit is very different from the Second Circuit. Their tradition is to give them a lot more often. So some of that makes just sense based on the way they practice.
Very, very interesting. Well, we love having you on the show and briefing our audience. And we'll have you back as developments happen. And of course, in the E Jean Carroll case, our audience and I wish you a lot of luck there, Robbie. And thank you so much for taking the time out to talk to us.
Anytime. It's a pleasure. Thank you.
Michael Popok, Legal AF, joined by lawyer extraordinaire Robbie Kaplan, representing E Jean Carroll, and commenting, of course, on the same-sex marriage law of the land that the Supreme Court for now has decided that they're not going to overturn. While you're here, hit the free subscribe button. Help us continue our march towards 1 million subscribers. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.